possible. Or maybe, for example, I have purchased an artificial intelligence. I have purchased, for example, Sophia, or maybe any other robot. Nowadays, so many robots are available in one or the other form, available in the market. So if I'm purchasing an artificial intelligence, and I'm inputting some information within that artificial intelligence, whether that artificial intelligence which is working by virtue of the information which is being sourced by me, which is being fed by me, would be considered as an AI that that create, like whatever is being considered or whatever is being created by such AI would be considered as mine? Is it possible? No. Or yes, it's again a challenge. Or should we have a mechanism wherein we are simply giving away, or maybe keeping these works which are created by the artificial intelligence in the public domain? Again, that's a question, or that's a challenge or an issue that is being posed by integration of artificial intelligence and intellectual property law. Now, for example, let's see different, just two IP regimes, copyright and patent law, right? Now, what copyright law says is that any original work which is coming from authors on, first, sufficient skills, second, labor and judgment. Sufficient skills, labor and judgment would be protected as a copyrighted work under the copyright regime. If it's not coming actually from authors on sufficient skills, or authors on labor, or authors on judgment, it may not be able to claim copyright protection. Now, the work that is being created by the artificial intelligence, whether that work or whether the artificial intelligence itself would be able to sufficiently produce such works by following this criterias which are fixed by the copyright law, that's again a question. That's again one of the issue that needs to be needs to be heard or needs to be analyzed further. Next is maybe patent law. What patent law says? Patent law says that if an invention is fulfilling new and taste, that means novelty, utility and non-obviousness. The invention fulfilling novelty, utility and non-obviousness taste will only be able to receive patent protection. What if, because the artificial intelligence are created in order to facilitate the human beings. Now, while facilitating the human beings in all the ways, an artificial intelligence could be such that is that is actually fulfilling this novelty, utility and non-obviousness test. What will happen in that case? Whether such artificial intelligence would be able to receive patent protection on his own name, that's again an issue. So, see, now these are the arguments on the recognition of artificial intelligence creations which is yet not settled, which remains which remains as an issue, but there are even some consequential questions that may arise even if we recognize artificial intelligence as IP holders. For example, if IP is being created by artificial intelligence, and if we are recognizing some such artificial intelligence as the owner of intellectual property, who would be able to commercialize the exclusive right? As I just mentioned before, whether the artificial intelligence would actually be able to commercialize the exclusive right, because exclusive right means to do something exclusively with the work that you have created or that is being protected under the intellectual property regime. Whether the exclusive right which is being granted to an artificial intelligence would actually be enjoyed or would actually be commercialized or would actually be utilized or enjoyed by the artificial intelligence, that's again a question, because the artificial intelligence works with what? With some prefixed programs or with some programming which is done by the owners or maybe the software developers of such artificial intelligence. Or maybe if the ownership is given to artificial intelligence developer, that means the one who has developed the artificial intelligence, as you know, as a reward for efforts and investment, what is the wrong, or what is, what, don't you think that it would be a loss of the one who's actually using the artificial intelligence, or who is actually feeding the final information or inputs in the artificial intelligence, the end user? Because if you are granting the rights, exclusive rights to the owner of the artificial intelligence, what is the wrong, what's the problem, or what is the wrong that's being done by the one who's end user? It could be because, see, the program developer or the software developer could be the one who has just fed some data, some input, maybe some data at the time of programming such artificial intelligence. But while nurturing that artificial intelligence to have such intelligence, maybe by by feeding some informations, by teaching certain things, the end user who's actually using such artificial intelligence, wouldn't such person should be considered as an owner of the intellectual property that is being created by such artificial intelligence? Again, this is an issue.